crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Hello and welcome into the attorneys. Thank you so much for joining us this Sunday evening. We really appreciate you being with us. Many of you are back and we appreciate that. But for those of you who may be new to the attorneys, here are kind of the ground rules. We love it when you join the conversation. The ways you can do so are at the bottom of your screen all throughout the program. Another neat thing that Hollis Wright makes available each and every Sunday evening is attorneys are standing by live to speak with you. So if you get a question and you want some free legal advice that will take place off air, a confidential conversation, all you have to do is pick up the phone and give them a call. Here's how you can get in touch with the firm. The numbers you need to know if you would like to text, some of your texters, so 205-670-1949, or you can give them a call at 205-324-3600 or 844-529-8255. That is 844-LAW-TALK. Leading our conversation tonight as we jump right into things, Carter Clay, a partner at the firm of Hollis Wright. Good to see you, my friend.
Good to see you, David. I hope you're doing well.
Doing well. Thank you.
Yeah, tonight we're going to be talking about bankruptcy. Obviously and unfortunately, there are a lot of individuals and families out there that have a mountain of debt that they're looking at, and they're faced with the option of either not paying bills or perhaps filing bankruptcy. Perhaps they've had an injury in the family and they don't have health insurance and they're confronted with a lot of medical bills, or maybe they've just gotten behind on their mortgage payments or other types of recurring bills on a monthly basis. But there are a lot of individuals that are out there that are facing these dilemmas, and if the viewers that are tuning into the show are confronting those types of issues, then this is a show that they definitely want to pay attention to and watch, because we've got an outstanding guest here tonight. Scott Allums is here with us. He practices in the area of bankruptcy and represents folks throughout all of North Alabama who are confronting these types of issues. Scott, thank you so much for being here with us.
Thanks for having me today. Look forward to the show.
Yeah, tell the viewers a little bit about you professionally in terms of your background and how you got started in handling bankruptcy claims.
I have an office in Bessemer, and I practice with my wife and her twin sister, so I take directions well. You know, from the
I hope so.
But we have an office in Bessemer, and I've been practicing since 2001, so started doing bankruptcy work in 2005. I saw kind of an opportunity there because the law changed in 2005. The bankruptcy code was rewritten, and lawyers were sort of kind of getting out of the field, and I thought, well, I'll just jump in and learn the law, and so been doing it ever since.
Well, and I think with the financial crisis we experienced in the country in 2008, 2009 time period, I think we saw a significant spike or increase in the bankruptcy filings. Was that your experience?
We did, and actually I read an article on the way over here that said that the filings were back up to those levels. So they're starting to creep. They took a dip down for a while, but they're starting to creep back up now, nationally.
Is there anything that you can pinpoint to attribute that to that's kind of caused them to spike back up? I mean, obviously the economy is doing really well the last couple of years for sure.
You know, people just incurring debt over time. It's just taking this toll on the consumers.
Let's talk about the different types of bankruptcies, because as I understand it, there are at least a few different types of bankruptcies that people could consider and should consider if they're confronting or thinking about filing bankruptcy. What are those different types of bankruptcies?
Sure, you've got mainly three main types. You've got Chapter 11, which is a corporate reorganization, and I don't do any of the Chapter 11 work, but for a consumer standpoint and an individual, you're looking at Chapter 13 or Chapter 7. The main differences are Chapter 13 bankruptcy is a reorganization. It's a restructure of your debt where the consumer puts forth the plan and you're asking the court to approve a restructure plan and you pay back your debt over a 3 to 5 year period. Chapter 7 bankruptcy, it's really a liquidation where you basically wipe away your debt. And when I say liquidation, because if you own a lot of real estate, a lot of equity and things, you may lose it. So that may be, there are certain reasons why you may do one or the other. But Chapter 7 bankruptcy is good to wipe away medical bills, credit card debts. If you're not behind on a car, you're not behind on your mortgage, it may give you an opportunity to get your fresh start. You know, it's cleaner, it's simpler. When I say simpler, you're in and out quicker, you know, 4 to 6 months, get your discharge, but you're limited to only once every 8 years.
I know that one of the issues that an individual or viewer would be concerned about is if they're contemplating bankruptcy, what is this going to do to my credit worthiness going forward? Am I ever going to be able to get a loan again once I file bankruptcy? And I want you to talk about that, but also talk about it in the context of either filing a Chapter 7 versus a Chapter 13 bankruptcy, because Chapter 13, as I understand it, you're going to pay off your debts. You're just restructuring the plan and the timing of how you're going to pay it off. But Chapter 7, you're totally liquidating, meaning the creditors are not going to get paid at all. Is it better to go through a Chapter 13 route or try to go through Chapter 13 if you're concerned about your credit worthiness going forward?
That's a good question that we get from potential clients all the time, is how does the different bankruptcies affect my credit? And you would think, right, that the common sense is if I'm going to file Chapter 13 and I'm going to pay these people back over a 5-year period in full, then my credit would be impacted positively faster, right? But it's not really the case, because the bankruptcy is going to stay on your credit report for 10 years. And a Chapter 13 bankruptcy lasts 5 years, so you're in the case for 5 and then it's on your credit for another 10, so you've got a significant period of time for an impact. In Chapter 7 bankruptcy, you know, you start that 10-year period quicker. And realistically, if I'm a creditor's perspective, I would rather have someone come in to obtain credit if they just had a prior Chapter 7, because I know that they just filed bankruptcy, they're debt-free, right? And they can't file bankruptcy another Chapter 7 for 8 years.
Okay. So they've really got limitations and restrictions placed on what they could do if they go into debt.
That's right. And I've got people who are filing Chapter 7 bankruptcy and then the following week or the following day getting credit offers to obtain new credit.
The other thing I know that people would be concerned about is what happens to my house. So I've got all these bills and I'm confronted and facing filing Chapter 13 or Chapter 7 bankruptcy. Am I going to get kicked out of my house? Is there some way that I can continue to make the mortgage payments through bankruptcy? Talk a little bit about those issues.
Well, in a Chapter 13 setting, if you're behind on your mortgage, I normally recommend someone to file a Chapter 13 because it allows you this period of time to stop the foreclosure. It's a chilling effect when you file the bankruptcy. It stays everything and allows you an opportunity to restructure. And the Chapter 13 bankruptcy will allow you to put that mortgage arrears into the case, bring you current, and you start making your payments moving forward.
And what about with Chapter 7? What happens with your mortgage in that type of situation?
Well, if you're current on your mortgage and you file Chapter 7 bankruptcy, you should just continue paying your mortgage and it really won't be affected in that, except unless you don't reaffirm the debt, it may not report on your credit, but you can still continue to stay in the house, make the payments. But if you're behind on the house, it's not going to help you catch it up. So that could be a problem if you're 6 months behind. You may get a temporary stay of the foreclosure, but as soon as you get out or as soon as the case is filed, the creditor may come in and ask for permission to reinitiate state court action.
Right. Okay. Do you believe there is an unfair stigma attached to bankruptcy? Because there are a number of prominent business people who have gone through some form of bankruptcy, but there does seem to be kind of a stigma with having to file bankruptcy.
I think there used to be.
Yeah.
You know, I don't think there's the stigma like it used to be anymore.
Right.
It used to be this black cloud,
yeah.
but I just don't think that it really exists anymore due to the number of people that's filed, due to, you know, it's something that it's legal, right? Congress put these laws in effect for us to be able to get relief.
Yeah, kind of reorganize it. All right, let's take our first break. All right,
good.
Let's take our first break right here. As we do so, a reminder, we'd love to have you check out Hollis Wright on social media, Twitter, Facebook, as well as Instagram. Just search the term Hollis Wright and you'll find them there. Stay tuned. We are coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Appreciate you being with us tonight. Interesting conversation covering a whole lot of ground on the subject of bankruptcy and what that means to you. A reminder, attorneys from Hollis Wright are standing by all throughout the program tonight, but you've got to give them a call. That's a free, confidential, off-air conversation. The numbers, if you want to text, is 205-670-1949, or you can call 844-529-8255. That's 844-529-LAW Talk. Carter?
Yeah, Scott, when we took a break, we were talking about the continuation of mortgage payments while a person is in bankruptcy. And a lot of times people are out there, they're either paying by paper check on a monthly basis, or perhaps they're paying by automatic withdrawal from a bank account. But do you have any recommendations or thoughts to individuals in bankruptcy in terms of how they should pay their mortgage payments during that time period?
It's a very good question, and I try to stress this with potential clients or when clients come in and they file, because when you're in bankruptcy, oftentimes a dispute may arise during the case. And so how does the dispute look like? Well, the creditor comes in and says, well, you're behind on your mortgage. And they come into court and they ask for permission or relief from stay, permission to proceed in state court or do whatever remedies they want without having to ask bankruptcy court permission. You know, or they in that motion, they usually outline that the debtor has missed X number of months. Are they always right? No.
Right.
But your client's going to say, no, I've made these payments. Is the client always right? No. So what do? We try to verify proof of what's happened so we can properly defend them in the case. And so at the onset, we always try to stress to our clients, please pay by paper check if possible. The old-fashioned check where you're writing a check and you're sending the mortgage payment in. Alternatively, have it drafted from your bank account, right? And so I always think it's a good idea to every month when you're paying, print off that old bank statement, because no longer do you really get a paper statement mailed anymore. It's all electronic. So the problem really becomes is if you're 3 years into a bankruptcy case and the mortgage company says, well, you missed one payment this year, you missed one payment 2 years ago, the clients, we need proof of it. And so if you haven't along the way been printing off your bank statements and paying this route, it becomes an issue, because number one, the client has to go to the bank, ask the bank for copies of the bank statements, and they may charge them if it's been too long. The worst case scenario is when someone comes in and says, Scott, I promise I made all my payments, and I have made them by money order. I went and bought these receipts, or I MoneyGrammed this money over to them. Isn't that good? And they bring in a stack of receipts that thick where they paid them, and I hate to tell them that that's not good, right? Because what have they brought me? A stack of proof that they bought a money order. Yeah. That's it. It's not proof that the mortgage company cashed the check. It's not proof they received it. So I always have the client, well, you know, the problem becomes is we need to trace this. And I called Western Union to see, well, how much is it to, I've got a stack of money orders here. And they said, well, for each one that you've got the receipt from the money order, it's $15 per receipt to track, trace, and provide proof of who cashed it, right? And they said, but also, if you don't have the receipt, you just got the store receipt where you bought it. Oh, by the way, it's $30.
Wow, wow. Now, of course, I guess if they truly did make the payment, then the mortgage company should have documentation on their end, I would think, that to be able to support that those payments were made, correct?
You're right, but their accounting systems are flawed sometimes,
Okay.
And especially when you throw a bankruptcy case in there. You know, anytime there's manual entry, you have service techs inputting these things in. Sometimes I've seen payments not be applied or misapplied or not even applied or applied late. So there are a whole host of issues, and you can ask through discovery or ask the creditor's lawyer to provide you proof of the life of loan transaction histories to provide this stuff, but you really need your client's information to verify this stuff.
Now, what types of information or criteria is the bankruptcy judge going to look at in making a determination as to whether he's going to allow the mortgage company to basically go to state court and pursue their remedies under state court, as opposed to maintaining that stay on collections.
Well, there's multiple factors the judge looks at, but the judge looks at, number one, are you making your regular payments direct? Our judges don't want people to lose their house, and they're in there for a reason. And our judges understand that there are financial difficulties and things come up along the way, and people, there are situations that can be rectified, right? And so many times, if this is their first bankruptcy case, this is the first time they've gotten behind, we can take that 3 or 4 or 5, 6, 7, however many months you missed, roll them into the bankruptcy case, right? And so you bring them back current again, and then you restructure those payments over the life of the case. And the issue really becomes is you've only got 5 years to pay 3 to 5 years. Let's just assume you're in a 60-month case. You've only got 60 months to pay the case off. So what happens is you default, you roll your payments in there. Your payments may have to increase. Right. So it's a cycle that can get into. But you really have to have been not making your payments. This is more. You've had more than one bankruptcy case. You're not your first motion for relief before a judge is going to give a creditor an opportunity to go back to state court to foreclose.
Yeah. Now, our firm, as you know, primarily handles personal injury cases such as automobile accidents, and I know in the context of bankruptcies, this is an issue that we face all of the time, because an automobile accident or a personal injury claim is going to be considered an asset by the bankruptcy court if the injured person is either in bankruptcy at the time they're injured, or they file bankruptcy subsequent to being injured but before they settle the case. And talk a little bit about how that plays out in the context of the bankruptcy court.
Well, that's something you have to really, the consumer or the injured party that comes to see you, is that we have to do a good job educating them, right? If you file bankruptcy, please let me know. If you're in bankruptcy, let me know. During this personal injury case, if you file bankruptcy, I got to know about it, right? And as a bankruptcy lawyer, I'm telling my clients throughout the process, do you have a claim? Before we even file the case, it's one of the things we talk about, do you have the right to sue anybody?
Right.
I don't care if it's your brother, right? We need to disclose it. Even if you decide you're not going to pursue it, let's list it, because the problem really becomes is a thing called judicial estoppel.
Yep.
Right? And
I'm familiar with it. Fortunately, it hasn't happened to me, but to go ahead and explain what it is.
Well, it's basically making two different positions in two different cases, right? If you don't disclose that you have a claim in your bankruptcy case, it may hurt you in that you can't pursue it in state court.
Yeah. So typically what happens is that they get discharged from bankruptcy without listing it as an asset, and then the lawyer in the personal injury case that's defending it finds out. He files a motion to judicially stop them from pursuing the claim because they effectively perpetrated a fraud on the bankruptcy court.
Well, all right, time to step aside for our final break of the evening. So we got more ground to cover, but just a few minutes remaining. So if you would like to take advantage of the opportunity to speak to those attorneys standing by live, or get in touch with us, that information there on your screen, we would certainly love to hear from you. Stay tuned. We've got the final segment of the attorneys that's on the way. Stay with us.
I'm attorney John Spade with the Hollis Wright Law Firm. If you have ever had a personal injury claim, the attorney handling your case has likely told you that a portion of your settlement would have to be used to pay back your health insurance company for the medical bills that they paid relating to your injuries. This is called subrogation. In this week's Legal 411, we are answering the question, what is subrogation and how does it affect your personal injury claim? When you purchase health insurance, you sign a contract with the health insurance company, which provides that in exchange for you paying a monthly premium, the insurance company will pay your medical bills when you're injured. Now, that contract has a paragraph that gives your health insurance company the right to seek repayment for the medical bills they paid if you in turn use those medical bills as a basis to recover from a third party that caused your injury. The idea is that your health insurance company would not have had to pay your medical bills if it weren't for the wrongdoing of the third party. Now, health insurance companies routinely put attorneys on notice of their subrogation claims by outlining exactly which medical payments the health insurance company is claiming a subrogation claim for and for what amounts. Throughout the handling of your case, your attorney should be aware of the amount of subrogation your health insurance company is claiming and whether all the claimed subrogation is related to your underlying personal injury case. That way, if your case resolves, your attorney can then negotiate a reduction of the health insurance company's subrogation claim. Subrogation is one of the many moving parts that can affect your personal injury settlement and what you stand to recover. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys. This is our final segment, so just about 7 minutes remaining. If you want to take advantage of the opportunity to speak with attorneys from Hollis Wright standing by live, you've got 7 minutes to do it. Carter?
Yeah, Scott, we talked briefly about the discharge in bankruptcy, which is, I guess, the end goal or objective pretty much with every single bankruptcy. But talking a little bit more detail about the timing of the discharge in Chapter 7 and Chapter 13, typically, how long it will take to get there. I know it takes a lot longer in Chapter 13. And then I want to talk about any post-discharge issues that you see in your practice.
Well, in the Chapter 7 bankruptcy, you're going to file the case. Within about 30 days after you file the case, you're going to have your meeting of creditors where a trustee's there has an opportunity to ask you questions, and your creditors have an opportunity to ask you questions about your case. And then 4 to 6 months later, you're going to receive your discharge. If there are no other issues that pop up, some creditor sues you inside your case asking a debt to be determined non-dischargeable or other issues. And so once you receive that order of discharge, that's the order wiping away the debt. In a Chapter 13 setting, if your plan is a 5-year case or 60-month case, you've got to complete your case. Once you complete the case, the trustee does a final audit. There may be some administrative things that need to be done at the end of the case, but then shortly thereafter, you're going to receive your bankruptcy discharge.
Yeah, let me ask you, because we were talking about car accidents and those types of things. What if an individual in a Chapter 13 bankruptcy, when they settle their car wreck case or if they otherwise come into a pot of money, maybe they've hit good fortune or won the lottery or something, can they just pay off the debts or accelerate the payment of the debts in the Chapter 13 context, or can they just dismiss the Chapter 13 and then pay the debts outside of bankruptcy? How does all that work?
Well, normally it's a debt or it's an asset, not a debt, but it's an asset, right? It's a claim that they had, and it's an asset that's normally part of their bankruptcy estate. And so once you settle a case or someone settles a case, you've got to come in and file a motion to approve the compromise. Ask the bankruptcy judge to bless or to approve the settlement. And in that settlement, you have to ask for attorney's fees to be approved and what we're going to do with the money. And so hopefully sometimes there are exemptions, which the debtor says to the court or schedules, I want to protect, or I'm going to protect, I've got some exemptions here that I can protect some of the money, I can keep it. Depending on what kind of case you're in, if you're paying your creditors back at 100%, paying them back in full, the court may let you keep some of the money. If you're paying your creditors back less than 100%, your unsecured creditors, well, the dividend, the increased distribution may increase. So your creditors may receive a windfall or more money than they would have received had you not received the settlement proceeds.
Yeah. Now, after discharge, everything's gone through the bankruptcy court. They get their paperwork that says they're discharged from bankruptcy. What issues as a lawyer do you see clients continuing to confront in the context of having filed a bankruptcy?
Well, I always tell my clients, after your bankruptcy discharge is over, it doesn't mean we're done representing you, because I want you to call me as soon as you receive a collection letter, a collection phone call, review your mortgage statements. What I want them to look for is changes, right? I want to look for little fees that are popping up on their periodic billing statements or the mortgage statement. I want to look for escrow account jumps, right? If your insurance and taxes have stayed the same, are they getting a notice that their escrow account is going to increase dramatically? And what I'm looking for, or what I'm concerned about is in the mortgage situation, is the mortgage company now assessing fees that were otherwise discharged or otherwise not disclosed inside the bankruptcy case that are popping up. Because what you see realistically is these mortgage companies transfer or sell these loans. And it's very, very common to be transferred or sold during the case. And then after the discharge, you may see another seller transfer. And so when the loan goes from one servicer to the next servicer, it has to be boarded up, the loan. And so during that loan boarding process, if fees or charges were assessed as non-collectible during the case, and the new servicer gets it in and hits a button to make them collectible, well, now you've got a fee that's popping up. And so I also want my clients to pull the credit reports. Let's make sure that everybody who is listed in your bankruptcy case is now reported as a zero balance. And those are some of the big topic things you want to look for, is make sure you don't get collection letters, because what you see is they will sometimes put these dollar amounts, or this debt was discharged in bankruptcy, and they may put it on your credit, right? And so what happens is let's say it's $100, but let's say you and your wife go to the Toyota dealership to buy a car, and you go in there and the finance manager says, well, I can give you a 6% interest rate, but I pulled your credit and I see that there's 3 charges here of $500, and if you go ahead and pay these off, I can now give you an interest rate of 4%.
Yeah.
So, you know, your wife is tugging at you, honey, I don't really care, I want that car today.
Yeah.
And so they go ahead and pay it. And so it kind of becomes, the creditor's taking a risk, but
Right.
sometimes there's rewards for them, and unless you're looking out for these things, you could be paying stuff that you shouldn't be paying.
Sure.
We are just about out of time, a minute and a half remaining, but I want to give both of you an opportunity for a final thought. And Scott, if you would, you go first, please, sir.
Well, thank you for having me today. Really enjoyed talking to you and talking to your viewers. I just want people to understand that bankruptcy is an option out there, and it can be a really good, viable option to give people an opportunity to restructure their debt, to give them a fresh start, and it's not the black cloud that people used to think it was, and it's not going to affect you long term, and it does give you an opportunity to restructure this and get back on track.
Well, thank you so much for being on the show. It's clear to me, and should be clear to all of the viewers, that you really know this area of the law. And I would just like to encourage anybody out there who is confronting a mountain of debt, they don't know what to do, they're at wit's end, stressed out about it, to call somebody like you. And maybe bankruptcy is not the best option for them, but I think it would give them peace of mind to call somebody like you, have an initial consult with you to find out what their options are so that they can make the best decision.
Appreciate you guys being with us. An excellent show, covered a lot of great ground. So thanks to you all, and thanks to you as well. We always appreciate you being with us each and every Sunday evening. Covered some ground tonight. Maybe now you're just thinking of a question that you'd love to pass along to the lawyers at Hollis Wright. You can still do so. That information on your screen, and you can always go to hollis-wright.com. That's the website. You'll find them in all over social media as well. We appreciate the time. We'll look for you next time right here on The Attorneys. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.